And do you want to sit there? Would you like? Is that okay? Yeah. Where was it? I'm sorry. Do you need to go this way, Cheyenne? I'm sorry. Where was it? Was it rumor or was it verbal? I think it's in a Lynn email. I think. I don't think it was just said. I think it was, but that's a good question to know where that is, because I don't remember.
Meeting of the Board of Supervisors to order. Please rise for the flag and
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Chairman, prior to the meeting, we had an executive session under Section 708A1 regarding personnel, Section 708A4 regarding litigation involving the data center, and Section 708A5. Thank you. At this time, Chair, we're into public comment. Lynn, do you want to give them the rules?
We allow township residents to make public comment, and it is a 3-minute limit. And we will call your name, and if there's anybody that fill out a card, please let me know. Thank you. Jim McConkey?
Jim McConkey of the City West, 4040 West 3rd Street, Hershey. I want to read something here that a blogger put up on Facebook. He tells of a woman who retired in 2016 to a quiet stretch of rural Georgia, he said. A data center went up 400 yards from her door. Not long after, her well changed. Sediment in the water, pressure gone. She hauls buckets to flush her toilet and cooks with water she's afraid to drink. The company says it commissioned an independent groundwater study and found no adverse effects on the area's water. She says her well ran clear for years before construction started. Both statements are on the record. It would be easy to pick a side here, he says. I'm not going to. I can't tell you what happened under one house in Georgia, and neither can anyone else who isn't holding the test results. What I can hand you is the thing that outlasts her particular story. There's a federal law called the Safe Drinking Water Act. It monitors public water systems and makes the results public, but it does not cover private wells. And over 40 million Americans drink from private wells. So when a giant new neighbor moves in and something shifts in the ground, the person on the well is the one who has to notice it, test it, pay for it, and prove it, usually alone. That's the gap. Not a villain, but a missing safeguard. So before the next one of these breaks ground near your town, here's the test to carry into the meeting. Who monitors the wells? Who pays to test them before and after, and who carries the burden of proof when something changes? The company or the retiree with the bucket? Ask it out loud, on the record, while the land is still empty, because that question is a lot cheaper to answer before the concrete is poured than after. If you've ever felt that the important decisions got made before anyone asked the people who have to live with them, you're not alone.
And you?
Good evening. I'm Alju Singh and I live on Cardinal Lane in Town. I want to start first by thanking our Board of Supervisors, you and the residents of South Hanover Township. I am personally indebted to all of you for working really, really hard and coming up with what is considered one of the best ordinances in the Commonwealth of Pennsylvania. And I'm saying that because I have witnessed other people, other elected officials in other townships referring to our ordinance as a model ordinance. And that is a huge applaud to all the people who've been working in this township. So thank you very much. Yet we know that this is work in progress. We know that even this, one of the best ordinances in the Commonwealth, has room for improvement. We have a golden opportunity right now with a pause on the proposal to make this ordinance better. I think we need to take this opportunity and work on the little loopholes that we found. The one, in my limited time, that I would like to emphasize on is, again, why are residential parcels been added and why are we rezoning residential parcels as industrial? South Hanover Township is predominantly a residential township. We have industrial townships in the Commonwealth of Pennsylvania. I understand we need to have data centers at least to some extent. So those townships that are already zoned as industrial, and those industries are barely surviving by a thread. Let's take, for example, either the steel industry or the coal industry, or any one of those industries that are fading out. The people who live in those townships gave informed consent to live in industrial townships. They knew the hazards and the risks they were taking by living in those townships. So why don't we have heavy industries move into industrial townships? Why are we rolling out the red carpet for these heavy industries to come into residential township where the residents have clearly stated we do not give informed consent for these data centers to come in. So we can achieve all of our goals to have the data centers that we want and need in areas that people are okay with it and not force it down the throat of people where they're not okay with it. So I think that's where we, not just at a township level, but even at a Commonwealth level, can function and achieve all our goals. That would be my request to you. Thank you so much.
And then how?
Hi, Annette Howe, Fox Meadow Drive. I'm reading a statement by Mary Ann. She couldn't be here tonight. She lives on Fox Road, I believe. The South Hanover Township Data Center Ordinance Overlay District currently includes 95 acres of residentially zoned land in addition to the industrial zone, former Pensipori parcel. To date, the reason why these residential acres have been included has not been made clear. The inclusion of the residential land is in direct opposition to the township's comprehensive plan, CP, which was last updated in 2019. Under the comprehensive plan, those 95 acres remain residential for future growth. It is important to remember that the comprehensive plan is a vision for the future of our township, a vision that can be changed if the township deliberately chooses a new vision through the adoption of a new plan. However, this is not something that should be changed simply because a developer asks for it. The governor's recent executive order protecting Pennsylvania consumers from data center impacts makes it clear just how important a comprehensive plan is for protecting communities from data centers. Under the governor's orders, permits will not be issued without documentation that the proposed project is consistent with the local comprehensive plan. The data center overlay district is currently defined does not appear to meet the requirements for data center permitting under the governor's orders, and more reason for the township to remove those residentially zoned parcels from the overlay district. That's Mary Ann's statement. Now, I'm Annette Howell from Fox Meadow Drive. I want to say thank you, Supervisor Busher, for saying that you would meet with us in your letter to the editor, and that you wanted to work with citizens on the data center. And I just want you to know we're happy to meet with you. If you can give us a date, that would be great. Or Super Tomasic. We need the data center on our agenda. We want the data center on our agenda. We want discussion. We want debate. I heard or read somewhere that you got a land use attorney. I want to say thank you. We asked for that, so thank you. I would like to know an update on that, what him or her is doing, saying. Just because we don't want an AI data center in the midst of a bedroom community does not mean that we won't ever use AI. There have been some derogatory comments about using AI to make statements, and just because we don't want it next door to houses doesn't mean we're not going to ever use AI. And lastly, I didn't understand what the solicitor said. I don't know what you're referring to. I would like that explained a little further. Thank you.
Robert Holbrook.
My name is Robert Holbrook, and I live in Fox Meadow. I have been a resident of South Hanover for 48 years, since 1978. I have several concerns regarding the information that has been provided to us, or rather, not provided to us. I understand that this is not a question and answer forum, but these are my concerns, and I found it easier to form my thoughts as questions. Regarding the parcels, why did the first overlay for the data center ordinance include residential and agricultural parcels? Common theme, I guess. And who was the author who added the parcels? Why did the amended overlay for the data center ordinance still include residential and agricultural parcels? Who made that decision? When we already have an industrial area designated for industrial uses, why include land that is not already zoned as industrial in the ordinance? Why not use and enforce the zoning we already have? I would also like to know if any of the supervisors have been contacted by HCI or any other developer or party regarding non-disclosure agreements. I'm also largely concerned about the lack of information regarding any alleged tax revenue from the data center. Is there any information regarding tax breaks for the data center? Is there any information regarding whether money paid by the data center to the community will be a one-time menial payment, which will have limited positive effect? Or will a data center be taxed in a meaningful way that takes into consideration the actual profit of the data center during its entire tenure? It's important that residents have a clear view of what actual tax contributions will be made by the data center in order to make sure that the community actually benefits from the data center. When talking about transparency, answers to these questions would provide information that we as taxpayers need to have. Thank you.
Lori Flickinger. Hello, I'm Lori Flickinger, and I also live on Fox Meadow Drive. And I have some serious concerns about the data center. First, I'd like to thank you for all of your time. I know that it takes a lot of time to do the work that you're doing, and we appreciate that. And I know that you are listening to what we're saying, and you have made some good changes. But since May 23rd, I've lost a lot of sleep over the data center and what's happening with the data center. And a few weeks ago, I was returning something at a store, and the woman asked for my address, and I told her Fox Meadow Drive, and she said, "Oh, that's a lovely address." And I said, "Yes, it is, till the data center goes in next to my development."
And I didn't tell her that I lived in Hummelstown, and her response to me was, "Oh, you must live in Hummelstown. Great. Hershey's known for chocolate. Hummelstown's gonna be known as the next Loudoun County." So, I'm here because I have a question that hasn't been answered from day one of when I found out about this. And I've heard 3, 4 other people ask the same question. How did all those parcels of residential and agricultural land get added? Where did that come from? It's residential and agricultural, not industrial. We asked the question many times. Myself, other people, we get silence. We don't answer the questions. We get one time, "I don't know." Now, as a teacher, if I had a student ask me a question and I did not know the answer to that question, I'd seek out the answer to that question, and then I'd let them know what that answer is. If I had a classroom full of students who were asking the same question, as you have a whole room of people here asking the same question, you better believe I would find the answer. If I didn't know the answer and I couldn't get the answer, those students would eat me alive. And then they'd spit me out and have me for breakfast the next day. I can tell you that I would lose credibility as a teacher if I did not work to find the answer. And I think somebody knows the answer to that question. And because we haven't been given an answer to it, there's a lot of speculation about what is the secrecy of it? What do they know that we don't know? And thank you.
Justin Gulliver.
Hello, my name is Justin Gulliver. I live at 14 Grandview Drive. I am here to ask of the board today. I don't have anything prepared, anything like that. Approximately a month ago, data center was paused. As of now, a lot of the residents seem quite upset. We don't have any updates, like what's going on. I know not everything can be shared because of legal and whatnot, but some types of updates, I think, would help a lot of the residents and us understand where the process is at, what's going on. Like, even on the agenda for information, August 2026 active project status report. Even though it's paused, a lot of us would consider it still an active project, knowing that at any point they can. And they may not have contacted you at all with anything besides, "Hey, we're pausing it." But we're asking that maybe some updates can be given to us, either under that report or following the meeting, just saying, "Hey, this is what's going on, this is what we can share, this is," and like I said, I understand not everything, legal terms and everything can be shared, but we ask that we can have some type of updates, where we're standing and what's going on. Thank you.
Question on a separate note.
Yes,
Did they get back to you after my letter?
absolutely not.
Okay.
They were out today and painted a bunch of marks, looks like they're digging up the whole road now.
Okay.
For those of you that don't know, it was at the last meeting, the water company dug up his front yard. So we're trying to figure out what is happening to Justin and his neighbor's front yard. Nothing data center.
Joe Cronin.
This one's more than one. I'm Joe Cronin and I'm at 25 Elm Street in Hummelstown. I just wanted to provide an update for members of the Facebook group as well as anyone here who might not be on Facebook. We were really happy to have dinner with quite a few of you at Aruga's in Hummelstown last night. It was a nice reset and allowed for neighbors to get to know each other outside of discussing the topic of data centers. For those of you who were unable to attend or were unaware of the event, we hope to see you next time, as it is definitely something we aim to do again in the future. For those of you not on Facebook, please see me after the meeting to exchange contact info if you would like to be included for an invite list, and I can reach out to you directly next time we do something like that. Next, Amber put a post out a few days ago regarding topics and frequently asked questions that we were receiving that we want to get a deeper dive on and get more research on, but we are asking community members to get involved with some of these tasks. We don't want people to feel like they're underqualified to help with this because it doesn't really require any special skills or expertise to work on these items with us. It might be as simple as making phone calls or sending emails to agencies or interested parties, attending surrounding municipality meetings other than the ones here, or just helping organizing documents and tracking progress. And there's still a lot of progress to be made on the ordinance itself, but these items are of equal importance to us. Lastly, I think it would be really good for all residents to familiarize themselves with what a community benefits agreement is. This was something that has been brought up a lot in the last couple of weeks. There's one person that I've talked to about it a lot, and we've done some research on it. But for those of you who may not understand or know about them, it's a legally binding contract that is formed directly between residents and the developer and covers both impact areas as well as what can be gained for us if they do decide to build here. We might not even need one if HCI for any reason would decide not to develop the land, but there is both a warehouse application and 2 applications relating to data centers currently submitted. So I think it would be wise to know how they work and start thinking about personally what you would want to see in one if we do have to draft one and use it. With the governor's new executive order on data centers, I would also recommend checking out some of the sources that we have on our page, which go into detail of how the order itself can be interpreted and whether or not it will actually benefit us in our current situation. And that's all for me.
Anyone else? I will turn it back over to Chairman.
This time, Chair will entertain a motion to approve the August 11th meeting minutes.
So moved, Mr. Chairman.
Second. Motion's been made and seconded. Are there any comments, changes, additions?
I have just one. On line 142, it says, Vice Chairman made a motion. It should be Vice Chairman Tomasic made a motion.
I was gonna let that go. Thank you.
That's the only thing I have.
Yeah. Mr. Clerk?
I have nothing, no changes, Mr. Chair.
All right, motion's been made and seconded. All those in favor say aye.
Aye.
Aye, motion passes. Okay. Mr. Solicitor?
Mr. Chair, Ms. Halleck asked what I said at the beginning of the meeting. I simply announced that we had an executive session, and I specifically had indicated the sections of the Sunshine Act that were implicated by that, so it was clear on the record when I was doing so. I wanted to answer a question about that issue. In addition, with respect to, I think, Mr. Gulliver's question about updates, we certainly talked to the board about that. To my knowledge, my partner Jim Diamond, who's been handling discussions with the council for the developer, I don't think anything substantive has been discussed at this time, but I expect that it will be at some point, but not yet. And I know that he has been forwarded and looked at, because we've talked, some of the suggestions from the community about additions to the ordinance. So I don't have anything to report at this time that would be of particular interest to the community. So,
Thank you.
thank you.
Mr. Engineer?
Thank you, Mr. Chairman. First, for discussion and action is McKinney Plan, 41 King Street Road, preliminary subdivision land development plan, request for waiver of salary section 5081A, connection to public sewer. The applicant is here with their representatives, engineer Colton Zimmerman and attorney Ambrose Hines.
Mr. Hines.
Yes, sir.
Before you get started, I want to sincerely apologize for my shutting you down last time. It was inappropriate. I was not at my best or having a good day. And I really am sorry.
Absolutely.
I'm
No
thankful-
apologies.
I'm thankful that Secretary Castle smoothly fixed the situation. So,
Okay.
but
I appreciate that, Mr. Tom. Thank you very much. Is this on? Okay, thank you. Again, we were here 2 weeks ago to request action on the waiver related to connection or the provision of a private system that would collect sewer from this 5-lot subdivision and transfer it up to the nearest public main. There was a lengthy discussion. We appreciate all the feedback. And certainly, before I get started, Mr. Lashner, he wanted to say a few words just because he's been involved in this longer than I have. I've only been involved for maybe last year, but Mr. Lashner wanted to say a few words.
Hello, gentlemen, and thank you for giving me a few minutes to talk with you. My name is Keith Leishner. We came to the township some 2.5 years ago with this idea of trying to develop a family plan and a family compound. And be honest, even though we've been at this a couple of years, all this legalese and hair splitting and discussion about subsection A of although whatever it is and so forth and so on, I'm here to make a hopefully practical and common sense argument to you about this issue. We are a family, and a few of the family members are here. They're embarrassed to have me introduce them, and I don't want to take your time, but nonetheless, what we have here are my daughter, my niece, folks who have worked their way up through the system over years and are just practical, everyday folks like many of you. We would like to have this waiver for about 5 reasons that I can think of, and I'll try to be as brief as I can. Number one, as I just mentioned, this is a property that is subject to what we consider special conditions. We are not developers, we're not trying to make money, we're not developing a thing to resell somewhere else. We are, in fact, a family just trying to put together a compound where we can live together for the remainder of our years. Secondly, I'd like to argue anyway that some of the conditions that have been put forth to us simply are an unreasonable hardship for essentially a family. So far, we've spent over $96,000 just on trying to get permits and right-of-ways and information and attorneys and contractors and the township. And to the best of my knowledge, from what these experts tell me, I'm going to have to spend at least an additional $55,000 to $69,000 before I can even talk about starting to break any kind of ground on any kind of activity. It's a significant amount of money for a family, even though many of you think it's not a significant amount of money. You're talking about a group of people who are a family. And then adding on top of that at least $300,000 to $350,000 to connect to the sewer system, it just becomes an insurmountable amount of money for us to try to deal with. Now, we don't think granting the waiver that we've asked for to let us put on-lot sewer systems is contrary to your public interest. In fact, we think we're not doing, what we're proposing is to put on-lot systems that meet the Pennsylvania requirements for approvable sewage systems. And we would do that for every house. Now, keep in mind, not every house is gonna be built day 1 to day 20. Some of our family members may have a year or even 2 years before they can even think about building because they have to go through the process of getting the plans finalized. So we're not gonna build 5 houses all at once. We're gonna build them over time. The time span maybe 6, 7, 8 years, I'm not sure. So again, putting together a lateral sewer system that hooks onto the township sewer system becomes a huge amount of problem for us, when in fact, somebody who's going to get a mortgage to build their house can in fact include the cost of an on-lot system in their mortgage and help ease the amount of money they have to put out of pocket up front. So it's a practical situation from our standpoint. We also don't think that you allowing us to put on-lot systems is setting a precedent. Again, we're a separate entity, we're not a corporation. I think last time we talked about, Ambrose talked about some subdivisions that have already been approved, asking for the exact same waiver that we're asking for. Okay, we're not a family, we're a family compound, not a commercial subdivision. Okay, the sewer system you're asking us to look at and put in, from our standpoint, requires some extraordinary activities. We have to get permits, we have to get right-of-ways from people that own other parts of the property that we have to cross. We have to get right-of-ways from the township. Finally, I guess, I would like to say that the township ordinance doesn't require rigid enforcement of every portion, okay? There's room for interpretation. And I think part of what we're asking for you is to make a reasonable interpretation with fairness and substantial justice in mind for our family and our family compound.
Thank you, Mr. Lesher. And at the last meeting, there was some discussion about doing this as a system that would then be turned over to the township. The reality of that situation is it doesn't really address the underlying problem or the underlying issue, which is the cost and impracticality of installing this system just to serve these 5 lots. Because even if we were to do that, that's not something that would really benefit the authority to have that line in there because it's not expandable. It wouldn't be something that they could build on top of to serve other lots. So, when you look at it from a practical standpoint, the authority, if it made sense financially to install a line down Hanover Road to serve enough residents to pay for that infrastructure, the authority would take that step to do that. It simply just does not make financial sense to do that for the purposes of serving these 5 individual lots. So that's what we had proposed. Now, we did also discuss briefly at the last meeting that 508, section 508, 5A of the SALO does address a situation where if it's 4 lots, it would be allowable to do this if it were only 4 lots in certain circumstances. So if that is the preference of the board, and if that's the only way this gets done, one of the members of the family is willing to take bite the bullet and say, well, I won't end up coming, and they would be willing to revise, and we put together a sketch of a revision that would just have 4 lots. If that's enough to get this over the line, they could do that. But the reality, to install this infrastructure for these 5 individual lots, it just is not financially viable, even if it were something that we then turned over to the township. In fact, it'd probably be more expensive to do do that. So, you know, what we're asking for is the relief related to the 5 lots. If the board is dead set against that and would agree to allow for that for just 4 lots, the applicant would revise the plan to comply.
I have a question, maybe 2 for our engineer. Okay, I think in our discussion at the last meeting, when we discussed having them build it and turn it over to the authority, the pump station and the force main, I think you said they would be able to use the street right of way to install. So therefore, you would not need the permission from the HOA, so that takes 50,000 or 50,000 out of the equation.
That is true.
Also addresses our concern that, okay, it's fine for you as a family, there needs to be an agreement, or what happens in the future when the lots get sold. Nobody's gonna live forever, sooner or later, in the future, other people will be buying that unless all your kids or grandkids wind up with it and passes for it. But still, our concern is the longevity and clarity of operation and maintenance. To my knowledge, I think we only have one other situation like this, and that's the Hershey School. And they have their own operator, and that's the only other private pump station that's in the township.
And that really is just, it's another reason why the expense long-term of building and maintaining is part of the issue. But the other part of the issue is just the expense of building. And 50,000 for not getting that right away. Unfortunately, if we were to design a system that is going to be something that the township authority would be willing to take over, it's more than likely going to be more expensive than the system that we were initially envisioning here. Because the authority is going to want to have certain pipe diameters that are maybe not serve as a lateral. They're going to want to have certain things with respect to the pump and the pump station. So that's, Lord, without running all of the numbers, I can't say for certain, but more than likely, based on what our engineer is telling you, it's going to be even more expensive probably to do that and then turn it over to the township or authority to the extent that they would want to take that. So,
Well, we appreciate your effort. I think your position argues more for the approval of the waiver than for building a system into the existing.
And I just urge the board really to think about the reality of what is the public benefit to having these 5 lots connected to the public system, served by a line that effectively only can serve these 5 lots, over just allowing these 5 lots to have on-lot sewer, which is what this area of the township is already designated as having under the Act 537 plan, right? So this is in the Olds District already. And I don't know what possible benefit, and maybe Mr. Lingle can share his insight, but to the extent what the benefit to the authority would be to force this connection for just these 5 lots, other than, okay, you get 5 additional customers, but that's not the goal of the authority. The goal of the authority is to have enough, have enough units to finance and maintain the infrastructure. And building all of this just for these 5 lots really, it's from a practical standpoint. And look, and if a line comes down here, we've already accepted that we would have, even a note on the plan, although it wouldn't be necessary, but we would have their own plan or have an agreement with the township. But when the full line is placed in right of way, or these lot lines, we would be able to connect, or we would be required to connect the systems at that time.
Mr. Chairman,
I have a couple questions. You don't need to answer them if you don't. Have you done any sort of testing at all, any probes?
Yeah, so this was, oh, go ahead, Colton, if you want.
So originally, the original submission, the intent was to have all lots served, so each of the 5 lots were tested or all lots served.
And a standby system?
What's that?
And most, the requirement now is that you have
Secondary.
the secondary system.
The secondary location, yes, would be.
Okay,
was
so,
identified.
so that's already been done.
Exactly.
Well, just, I guess a comment to the board is, when this amendment was added, at that particular time, it was difficult. Developers didn't seem to want to hook up to the sewer. And we wanted developments to hook up to the sewer because public health and different things like that was the idea. The conditions apparently have changed a lot now. Most developers, that's the first thing they want is their public water, public sewer, available. And I'm not sure at this point exactly why 5 lots was chosen. I just, we had to have a number somewhere, I guess. So I don't know.
You mean 4 lots here, the original number was.
Well, it's
over 4.
Yeah, over 4, yeah. So I don't know. I mean, if it appears to me that they've already done testing, and they can be approved and have a backup system, and they're agreeing that if I understand correctly, they would agree that a public sewer comes to the area, they would not argue against connecting. I don't think they could argue, but they would agree.
And yeah, that was my
Yeah,
point. I mean, we couldn't argue if it were within a certain distance anyway, but we would just have it as a note on the plan that if it were placed along the frontage of these lots in the right of way of Hanchy Road. And I don't know whether there's a plan to do that from the authority's perspective. Certainly not in the near future, is my understanding. But certainly we would be willing to connect at that point.
Well, basically, it would be a developer who would build a system if they wanted to do further development on the property. The authority wouldn't just build an additional sewer system, It would be a developer building it to meet township requirements.
Yeah, if the line were extended along, either way, if the line were extended, the main were extended along Hampshire Road.
Right.
With the lot layout, another developer would essentially have to start from scratch, essentially knock down whatever 5 houses we put there and whatever they were going to build.
I think
It
he was
would be
talking
a
about,
completely
Well,
different.
he was talking about somewhere else.
Oh, yeah,
somewhere else, yeah.
I'm sorry.
Yeah, I don't know, Mr. Chairman, I think if they have already done testing, it would be approved and then have, on each level, have an area for a backup system. I think that's a pretty convincing argument maybe for a consideration.
Have you done a cost estimate that you could provide to us of what you're proposing in terms of, if it was an on-lot system, what other costs that you're including in there?
I'm not sure I follow you. So we did do a cost estimate of like what it would cost to build the lateral system that we had initially shown or designed. That was what triggered this secondary request for this waiver. But, I mean, it is still going to be significant cost to go back basically now and install these individual on-lots. I mean, there's going to be
Colton, I don't know if you have something off the top of your head that would.
For normal system, typically, you're looking at $30,000 to $35,000 per
Yeah.
lot to construct that. Whereas, so 5 lots, you're about half the cost of installing that public system.
Well, Isn't your proposal including paying a fee for the part of the extension?
Well, the proposal would be to pay the initial, the tapping fee or whatever the cost would be to extend to the road. So that's the way the ordinance is written. It's a fee for the cost of making the connection to where the public sanitary sewer system would be located when it's extended to that location. So it's not for the cost of building the system, it's the cost that you would otherwise pay if you were gonna connect to the pumping system anyway. But we would pay that in advance, the tapping fee, and that tapping fee includes a cost for the actual, and your solicitor can explain this, but the tapping fee includes a component that is the cost of building the infrastructure out to get to that part of the township. So whenever anybody pays a tapping fee, a portion of that is for the cost of the overall system of bringing it to that area. So, but we would be paying that tapping fee now, even though we wouldn't be making the connection until the line will be actually run in part of these.
I think we would have some questions about how that money is managed, but, you know, that's a whole other.
Yeah, well, I would have the same questions, because those things, you know, if it's 20 years down the road,
Right, I think it's a
you know,
negotiable item.
those agreements are
You know,
a
really.
problem.
Well, I don't, if it's 8, 10, 15, 20 years down the road, it's gonna be more than double what it is now. And if we were to go ahead and grant the waiver, I don't know that I would want us to take a tap in the fee.
I was thinking the same thing, yeah, I don't think so either.
I mean, that's certainly up to the board's discretion. Or if you wanted to take it and then we would pay the difference, or I don't know. Whatever is the board feels is appropriate.
Well, I think there would be questions on how that money is held and managed, you know, so,
Yeah, I mean, the ordinance does provide for that, right, so that it would be, the money is retained by the township and applied toward the cost of installing the system in the area at the time the sanitary sewer system is extended to the subdivided area. It's certainly, there are provisions in the ordinance that would deal with that, but honestly, however the board feels is appropriate.
Well, in the future, as Mr. Castle pointed out, tapping fees are based on the cost of building the system, and that, we don't know what that would be.
And that's fair.
So it doesn't include capacity at the treatment plant?
There's a component of it that's capacity as well.
Yeah, that could change in the future too.
I have a question for the engineer, if we may. During this process, we've talked about what the, future tap-in fees and what the implication to the township might be, 10, 15, 20 years from now. On-site sewer, what might be an issue that the township would have to deal with in the same time frame, 10, 15, 20, 25 years down the line? Or is it mainly just housed with them, and if they need us, they get us, but otherwise it's all their problem?
Yeah, it's really their problem. They're in the Olds District. They have to maintain the system, pump it out, provide those documents to the township. If there are failures during that time, the pumper will identify that, any issues, and then they're gonna have to address it. That's why you have a backup secondary location. And I think if I might go beyond your question, there's two sections in the ordinance again, and I think Attorney Hines had addressed that. There's the four lots and less and above that. 4 lots and less was the tapping fee. 5 above that would have been the cost of installing the system. That's where the two different costs come in. But in this instance, again, it's not like it's a private street with a cul-de-sac, and the system needs to be eventually constructed within there to connect homes. if it is ever constructed, it's gonna be along Anshu, and really it's laterals from those units to the system.
Which would be on the landowner.
Correct. And I think if, again, if the board is leaning towards this, my recommendation is that you just make sure you have an ironclad agreement that if public sewer is ever extended, they do connect. Technically, the township ordinance requires connection if the structure is within 300 feet. And I'm not sure all of these lots would fit that condition. I looked at it more closely, but I think some of those ones in the back, maybe more than 200 feet. I think I agree that taking money now that in the future is gonna cost much more is probably not the smart bet. The smart bet is, if the board is leaning towards that, just make sure the agreements are in place, that knowing that they may be outside that 300 foot, they will connect at the current cost of the connection fees as well as, the construction of the lateral completely at their cost, within a certain time frame of notification of the township.
And that's perfect.
Yeah, it might be wise too to have on the plans, the right of way for the lots in the back, if they have to run their lateral across one of the lots in the front to get down to Ham Street.
Yeah, well, each of the lots do have frontage, so all of the lots do have frontage and would be physically able to do it even if they didn't have like a designated ability to directly cross. So they physically, all of the lots would be able to run laterals
So they would
within
have
the lots. But
space to run up besides driveways and so on.
Yeah.
And Mr. Studer, I believe, we would have no problem putting together right-of-ways if that is, a better alternative.
Mr. Solicitor,
I would just like to bring up too, all the sewer infrastructure we're doing now, in 3 areas. We have 2 more to do by the end of 2028. There's no saying that you may just build your home and get settled, and we could get another mandate from DEP, which mandated the 5 areas that we're doing now. We could get a mandate, our next mandate could include that area.
And that, I think that's the expectation from the landowner.
I'm just saying, be aware that could very well happen.
I just think in the way we could finance it individually, and the overall cost would still be less than trying to build the system to tap into the existing sewer.
Yes.
Mr. Solicitor, is it prudent to make a motion contingent upon an agreement with the township for future sewer development in the area?
I think it would make sense to make a motion to grant the waiver subject to an agreement acceptable to the solicitor with regard to the compliance issues that we talked about here. And so the waiver would be conditional, I'm sure Mr. Hines understands that, an agreement that is both drafted, acceptable, signed, and probably approved by the board subsequent to this.
Yeah, and that would be approved as part of the final plan. The reason we're asking for this now is because, as he explained, we've already spent 96 times, so we didn't want to go through another round of revising the plan to address all of the other comments.
That's fair. You're developing five home sites.
Yes.
And subject to the same rules that everyone else is, so.
Yes, fair enough.
So I think that what the township is asking for is not just a note on the plan, but an actual signed agreement which details all the rights and responsibilities that people are accepting, and I'm sure that you would agree to do that as part of the condition.
Sure.
For granting the waiver, that signature would be necessary before the waiver is effectual. Is that fair?
That's fine.
Okay.
Mr. Chairman, I would make that motion.
Second.
All right, motion's been made and seconded. Is there any discussion?
I just want to say one quick thing. At the end of right before you guys left at the last meeting, on the same lines as Mr. Tomasic, I stated, we want you here.
It's not the same situation as we talked about, you know, prior during public comment and other meetings. We want you here. We want you to be part of this community. We just got to figure out how exactly that looks. And I think today was a major step, so thank you.
So,
Motion is second.
the motion is to conditionally approve the waiver request to allow on-lot systems to be installed with an agreement to the satisfaction of the township worked out between you and our solicitor, and which would provide for the future connect or require the future connection to public sewer if it gets extended to that area. Is that covered?
That covers
I think
it.
that's it.
All right. All right. Any other discussion? Hearing none, all those in favor say aye.
Aye.
Motion passes.
Mr. Hines, and again, the time does expire.
Yes,
So
I'm
you'll-
able to.
Are you
We'll
putting
probably
on the
put you-
agenda, anything else for the planning commission? Just time.
She doesn't know. She doesn't know.
All right, thank you.
Because you're the meeting.
How do you know?
Like you're getting.
Thank you very much.
All right, so next on the agenda for discussion and action is the Cary Stormwater Management Plan, 12 East Field Road, Stormwater Management Plan, agreement. This was originally under the name of Christian, but as it turns out, it's another family one, and Cary is actually the applicant here. So if you see the name difference, that's why. The agreement is, O&M agreement is in the name of Cary. They've addressed all of our technical comments. We do have a letter dated August 19th, which has the standard requiring the O&M agreement. We would also, and the inspections that are required. We would also, if the board is so moved to approve this, we would make the approval conditioned upon execution of the O&M agreement. We don't have the signed agreements yet, or the township doesn't. And also the payment of any outstanding fees. This applicant is proposing to install a semi-detached garage, breezeway, and patio. So we have no objections to approval of the plan and O&M agreement contingent upon addressing comments of our August 19th letter and conditions stated tonight.
Okay. Mr. Chairman, I would move that we approve this would be a stormwater management plan, I guess is the proper term, for 12 Eastfield Road, subject to the comments from the engineer concerning fees and the operation and maintenance agreements.
I'll second that.
Motion's been made and seconded. Is there any discussion? That would be subject to the engineer's comments.
Yes.
Right. All right, hearing none. All those in favor say aye.
Aye.
Motion passes.
Thank you, board. Next for discussion and action is for the Swatara Creek Pump Station Force Main Replacement Project. Application for payment number 1 from Track 1 LLC in the amount of $560,310, and we have reviewed that, conducted the required observations, and we do recommend approval of that application.
Chair will entertain a motion to approve the payment application number 1 to Pac One LLC in the amount of $560,310.
I'll make that motion.
Second. Motion's been made and seconded. Any discussion?
Yes, I'd just like to say, I was down there yesterday, looking over the finished force main project, and they did a very nice job. The stream banks have been lined with rock, and they build a nice access road down the side there with compacted stone, which would make it much easier in the future if we ever had to do a bypass in the system again, as we did in the 2011 flood. So, yeah, I was very impressed with the work they did.
No, I'm fine. All right, very good. All those in favor say aye.
Aye.
The motion passes.
Thank you, Board. And I will say, just to remind you, the township had gotten $450,000 CFA grant for that project. This application payment covers that. So the time was getting late on that grant. So we're happy that that's taken care of. Next, for discussion and action is an inflow and infiltration study proposal from us in the amount, from number 2, in the amount of $20,200. That was before the sewer authority at the prior meeting for their recommendation to the board. Their recommendation and their action was to table that at this point in time. The manager has been going through some old files and believes that there's a lot of information that can be used. The chair of the sewer authority believes that the township crew can do a lot of this work, as well as, I guess, in consideration to add some staffing. So, just wanted to relay that was the sewer authority's recommendation at this time.
I think at this time, I would recommend that this be tabled to future meeting.
Yes, I agree.
It's fine with me.
It's a unanimous decision, it's tabled by acclamation, you can move on.
Thank you. Next, just for information, is our regular August 2026 active project status report for your information if you have any questions. Otherwise, that's all we have, Mr. Chairman. Thank you.
Manager's report.
Board members, in your packet were the meeting dates for next year, and hopefully you had a chance to review them. They were checked. One request, actually 2 requests we would like to bring forward to change is the public safety meeting. All of our meetings are at 6:30. The public safety meeting and the zoning hearing board are scheduled for 7 o'clock, and we would like to have them changed for 2027 to make all the meetings the same start time.
That'd be 6:30. Well, one thing I was gonna mention, that when you do publish that list, you might wanna put the 2027 at the heading.
Yes. Everyone is fine with the dates. They have been checked and rechecked and checked again. I would ask our administrative leaders.
I'm so moved.
Second. I have a question here. We have the sewer authority at the same time, the 6:30, as the board meetings. Shouldn't that be
Yes.
remaining at 5:30?
5:30, yes.
Yeah, that's right.
Mhm.
I'm glad you caught that.
Yeah,
Yeah, that would not be
I
fun.
can't
It's
set
rather
my
be a vote.
personality that much.
Well, even now, sometimes if the sewer authority meetings went long, we were pressed to get it finished.
All right. I did want to give the board an update. The Brinzer Park playground project has begun. We have removed all of the playground equipment from the site, and the construction of the new equipment will begin within the next week. All the old equipment has been taken out.
Chairman, you want a motion to approve the meeting dates and times? So moved, Mr. Chairman.
Second. Motion's been made and seconded. Is there any discussion?
That's with,
With the change
Changes,
to 5:30 for the sewer authority,
And 6:30 for public safety.
and 6:30 for public safety.
Mhm.
Zoning. Also, board members, this Friday night, we have our last summer concert.
we didn't vote on this yet.
No, okay. Any other discussion? Then none, all those in favor say aye.
Aye.
Motion passes.
Okay.
Now you can talk.
This Friday, we have our last summer concert, Friday night, at the amphitheater. And also just an FYI, as a reminder, on Monday, most of the staff will be involved in an audit through DEP. DEP will come in and audit all our outfalls, all of our records, all of our public works building. And so it's been quite a process trying to get that all together to get an A+ on our audit.
And we thank you for all the work you're doing to get all that together.
If anybody'd like to come and join us.
Under the chairman's report, I wanted to have a discussion about the budget and our future needs. At this time, our municipal tax rates have not been increased since about 2006, I guess, was the latest. But it's generally, it's over 20 years. The rates that you've seen that have increased are your school taxes and the county taxes. I estimate our tax bill has probably gone up about 20–25% over the last 4 to 5 years.
At least.
Yeah. However, our costs keep going up. And we haven't increased the taxes. We are getting to the point where we're gonna need to take some action. If we put it off, you're gonna get hit with a big tax increase at one point in the future, like Gary did. We don't like to do that. It would be much better to have smaller increases over a period of time. We are in the process of putting together a capital budget. We need to know how much it's gonna cost to replace all our equipment. Those trucks are expensive. And the fire department. We just bought a 3,000-gallon pumper tanker that's 5 or 10 years old for $825,000. That's used, and that was a good deal. Nowadays, you're looking at close to $1 million for any piece of fire equipment. The radios themselves are gonna cost $290,000 just to replace them. Some of them have failed already, so we have to do that. Their air packs are getting out of date. There's another more than $100,000 for that. And that doesn't include their equipment, their trucks and other equipment that they need to, we have to budget for that. So we're probably looking at increasing the fire safety tax. We are also gonna have to look at our municipal equipment and the other expenses we have. So we've been doing the best we can, and we work hard to hold the rate steady, but at this point, we feel that all our professional services, they don't work for free, they have to get paid, that increases. It's hard to get new people, wages are going up, we have to keep our employees gainfully employed. They do a great job, but they need to be compensated properly. So at this point, just wanted to bring this out that we are looking at our budget, come up with realistic costs and what we will have to do for our tax rates. But, that's where we are. And the federal taxes haven't gone down. Nothing's going down.
The first thing that Pennsylvania State Association of Township Supervisors tells new supervisors when they go for their training is that if you think a volunteer fire company is expensive, wait till you get a paid one. And we're also having, there are recruitment problems everywhere. So it just is, it's a reality. It may seem expensive, but it is not nearly as expensive as it could be to give them what they need to keep us safe. And there are a lot of municipalities around us who have gone hybrid with paid and volunteer. And we're kind of lucky, right?
Yeah, Mr. Chairman, if I may. First, I want to thank our professional services and our staff. The increase in professional services isn't because of the rates that they charge. Actually, their rates are lower, if not average, to what some of our other municipalities of this size are charging, but their hours have gone up. To our staff does a lot with a little. You know, as you drive around other municipalities, you see, you know, those municipal plates on the back of cars. Our staff doesn't drive municipal cars. Supervisors don't drive municipal cars. Some other municipalities around us and around the Commonwealth do. So we try to do a lot with a little. And I know my fellow supervisors are sick of hearing me say this, and many of you that have been meeting after meeting, I used to serve on the school board. And I witnessed over time what happens when you don't raise taxes a little bit every year. Now the school district is dealing with possibly an $80 million building project because their buildings are falling apart. We don't want to have that happen here. We want to make sure that when you pick up the phone and you call the fire department, that the fire department shows up. That's number one. Public safety is number one. I also would be remiss if we didn't talk about the state and the county. Not necessarily how they've increased taxes, but how without their partnership over the last many years, decade plus, we would be in a financial hole right now, if not for the gaming grants and some of the other things that we get from the county. You know, we talk about the Hayshed Road expansion. We got significant grants from the state through our state rep, Tom Mahaffey, through our state senator, Patty Kim. Without their help, we would be in a financial hole. So I think it's important to talk about the help that we are getting from taxpayer dollars from the state and the county. So that's important to note. The other thing that I wanted to mention was there are some holes in our taxing authorities. If possible, I would like us to consider, and the solicitor to consider, us to ask the solicitor to consider looking at our ordinances around our taxing structure about an amusement tax or a hotel tax, because we don't necessarily have the industry structure that other organizations and other municipalities have. So I think there's some things that we can look at in helping us fill some of these gaps in our taxing structures in order to make sure that when the fire department gets called, they show up, which they've showed up at my house now a couple times over the last couple weeks. You know, I want to make sure that they show up. You know, increasing a little bit, to the chairman's point, increasing a little bit over a long period is much better than increasing once or twice over a shorter period and having it be larger. So as much as I hate increasing taxes, we do have to consider the broader good for the community as we consider some of these things. So with that, Mr. Chairman, I will conclude my statement.
concludes my report. At this time, Mr. Chartberg.
Thank you, Mr. Chairman. Proposed motion to the board to authorize the transfer of $71,308 to pay our debt service on this building in the fire hall. I have that before you and ask for the approval.
Chair will entertain a motion to authorize the transfer of $47,324.98 from the general fund and $23,983.02 from the fire protection fund to the USDA sinking fund on or before September 8th, 2026 to fund the semi-annual debt service payment of $71,308 from the USDA sinking fund to the USDA and to authorize such debt service payment due on September 8th, 2026 for the Township of South Hanover General Obligation Bond Series of 2017.
So,
Second.
Motion's been made and seconded. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Motion passes.
Thank you, Mr. Chairman. Just to note that we have received a $300,000 grant from gaming funds, but we've not yet received the agreement. When we do get the agreement, they'll be submitting this for reimbursement.
Okay.
That's all I have, Mr. Chairman.
All right, thank you. Okay, is there any other business from board members? Jack?
Yeah, I'd like to just talk a little bit more about the new force main at the Swan-Era Creek pump station. When I was in there yesterday, we looked at the flow rate and the back pressure on the system. Now, the old force main was in use for over 50 years. And I would guess that over that time, it had some incrustation and some sediment buildup in the system. And the last time that force main failed and blew out, we were running roughly 50 PSI back pressure in that pipe. Now that pipe ran quite a distance down on our side of the Swan-Era Creek, and then crossed the creek, and then ran directly to the headworks of the Dairy Township sewage treatment plant. So it was quite a much longer distance. Now the new pipe goes directly across the Swan-Era Creek, and only a short distance on the other side, and then it goes into a gravity sewer. So there's very little back pressure now, and plus it's a larger pipe, it's a 16-inch pipe now. So our back pressure has dropped to only about 1 PSI now. Yeah, it's much, much lower. And so the pumps now are drawing much less electrical power. And they're actually delivering almost double the flow. One pump will almost certainly handle all of the flow that we normally need. Now, there's 3 pumps, they get staged, you know.
Right, sure.
But, so in the future, you know, we're mandated to add these new areas like Duke Street and this corner and Grandview Heights. When that comes about, it's very likely we won't have to do much at all as far as increasing capacity at the Swan-Era pump station.
Board members, Jack, I did want to jump in here because there was discussion last week in one of our meetings. We gotta remember though, we went through a course of discussion with DTMA when they saw the design of, the engineering design of that force main, and there was concern. So when all of us are no longer here, we just want to make sure we have it in the record that they allowed us to put that 8-inch pipe in there I mean 16 as opposed to the smaller size, but we promised them that it wasn't because we wanted to get the flow going sooner. It was for additional adage in years to come. So when we're not sitting here, we just need to remember, I mean, the engineer might be here, but,
You know what, I do want to put on the record, he is youthful, so that makes sense.
so,
I got you.
so,
Like to table
Supervisor
that statement.
Studer, I just wanna
You're out of
make
order,
sure, and I'm excited, and I'm also excited to see if the electric bills will go down.
They should.
If there's a change in anything with that pump station, like you said, that company has done an awesome job.
Yes, they have.
And it has really been smooth. If you go down to that area, although the pipe runs under the creek, you can see the areas that they had to lay stone and add grass and so forth. And
Yes, they did a really good job at restoring the banks. and
Yeah.
so-
But I do want to just put that on record saying, don't forget, we promised DTMA that we would not,
Right, well,
that was just for future use.
one other thing you have to remember though, back when the last time the force main blew out at the old one, I believe it was 2012 maybe, or it was not long after the 2011 flood.
No, it was I was here for it, so it was the 2018 flood, or 2017?
Oh, I'm sorry, yes.
We had a blowout in 2019, like 3 months after we were underwater for the flood.
That's right, it was the 2019 flood.
And that was just not.
Well, what we did at that point, we realized that the old force main was really in bad shape. And so at that time, when it blew out, it was running at 50 PSI. And we reprogrammed the frequency drives to lower the pump rates so that the pressure dropped to 30 PSI. And that's what it was up until this new main was put in. So we are running at a lower rate even now. And we're still almost, not quite double the flow. So
Okay, thank you.
we should be okay. I think, now, one thing I would recommend is that we should probably go over the flow meter and have it recalibrated. Because it was moved in the system and, just to make sure that we're really sending the amount that we think we are over to DTMA.
Thank you.
Do we need to readjust the frequencies that we're pumping at?
I
to
don't
account
think
for the
so.
pressure?
I don't think we need to. I would leave it as is for now. Let's run for a while and see how it goes.
I would recommend, and I think the foreman is going to get that flow meter recalibrated. I think we look at it at that point and want to make sure we're within whatever we promised to do.
Yeah, I think,
I think that was discussed because we didn't know if we needed to do it, because if it's not correct, we will get a phone call.
Well, I'm not sure because there's more than our flow going into that gravity main.
Just so we're not paying for that extra.
Right, well, I think that's what my point is. We want to make sure we aren't paying for more than what we're actually sending over.
Correct.
But, I think we should just leave things as is right now. And I believe Controls 21, I think, can do that calibration. Isn't that right?
I'm not sure, the foreman.
I'm just looking back at Shane,
Yeah, the
because
foreman's
he's
handling
been
it.
working, he's been in the department. Thank you.
Okay, that's all I have.
I just think it's important, there were a couple of questions and I think some underlying, some undertone to some of the questions posed here tonight. First of all, this board will never, has never, I have never signed a non-disclosure agreement. Our solicitor has told us that he would never allow us to sign a non-disclosure agreement. So just because you're not hearing information from us does not mean that we have not signed or that we've signed a non-disclosure agreement. So let me say that again. I have never, nor would I ever, sign a non-disclosure agreement. Period. Full stop. End of statement. Also, the conversation around, the governor's executive order, how it impacts our conversations and some of the things happening, as well as the tax breaks and whatnot. I can't answer that right now because we don't know what we're talking about yet, right? So, what the developer applies to the state for, we can't really stop. So if the developer decides that they want to get full tax breaks, I don't know, Mr. Solicitor, that we can stop.
But I think I think it's important for people to understand that what the governor has laid out are conditions for getting state approvals and state funding, not necessarily local approvals. I think they're important in the sense that they require developers kind of statewide to adhere to certain things, and he carries a big stick in terms of approvals and so on and so forth, and certainly the PUC and its chair was at that meeting, and if you don't have power, you don't have a data center, and so that's an issue as well. But I think you're right. I think it's premature for people to link what we're doing on the local zoning level and what the state is doing, although I think they're both beneficial to everyone. I heard Mr. Cronin speak about the community benefits agreement, which is usually between the community and the municipality and the developer. That too it's worthy of study. I think his suggestion is excellent to see what it is, but I think it's early in the process. I think that is a conversation that must happen, will happen, but I think it's not there yet. But I agree entirely with Mr. Cronin that the contours of that deserve study, deserve conversation. I guess what I'm trying to say inartfully is there are many more chapters to write on that issue and a lot of different decisions to be made. And we should, what did Churchill say? It's not the beginning of the end, but the end of the beginning. So it's the way that works.
I also wanted to state that, there was a comment about us hiring a land use attorney. One of the reasons we went with Mike and his firm was because with things that we didn't know were coming down the pike, his firm has very excellent attorneys that can fill in the blanks for us and with us and beside us, and in turn with and beside you all as our residents. So, as Mike has stated numerous times, Jim Diamond is working on this with us and beside us, and in turn you, to get us to where we need to be and where we are going. And I thank Mike and I thank Jim for that work. And recognizing where we need to go, we're going to bring in the right people and the right professionals. And that's part of the reason we went with Mike, besides his sunny disposition at these meetings. We also went because we knew his firm had experts in fields that we didn't even know about years ago when we hired his firm. Also, the comment about me being willing to meet with residents. I don't think anybody in this room that has been here meeting after meeting can attest that I have not been willing to meet with residents. I've stood outside of this building for hours after this meeting to talk to you. Now, sometimes those answers leave both you and me a little upset at times. However, I am always willing to meet with anybody. But I also reserve the right to choose who to meet with and when to meet with them. And if I feel that you are playing games, or you have an ulterior motive, or you're furthering misinformation, I won't meet with you. Because that is not the goal. The goal is to get us to where we need to be, and that is to set regulations for a data center if they choose to come here. And let me say that again. If they choose to come here, there needs to be a regulatory structure that holds them accountable, doesn't prevent them from coming here, because we can't do that, but holds them accountable and sets the rules of the road. I've said that meeting after meeting, and I mean it. That's the point of the data center ordinance. It's not to promote them, it's not to bring them here, it's not to ask them to come here, it's to set the rules. And if we don't do that, as was stated in the Hummelstown Sun this week, or in the Sun, sorry, I still call it Hummelstown Sun. The Sun, I think Drew's article was phenomenal and spot on. And if you haven't read it, you should. It's about setting the rules of the road and making sure that if they choose to come here, it's by our rules, not theirs.
Are we ready for payroll invoices? Okay. Mr. Chairman, I move that we approve accounts payable in the amount of $762,941.58, payroll of $30,258.01, and that brings us to a grand total of $793,199.59, and that this be included in the minutes.
I'll second it.
All right, motion's been made and seconded. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Motion passes. Chair will entertain a motion to adjourn.
So moved.
Meeting adjourned.